It is 7:00 a.m. You have been on the move for 14 hours straight. You are completely drained. Your luggage feels incredibly heavy, and your only desire is to exit the airport and return to your residence. You approach the Customs and Border Protection agent at the inspection station. You pass your passport beneath the window, and the situation seems routine. Then the agent glances at his computer monitor. He does not return your passport to you. He enters something into the system. He lifts a telephone. And then he speaks those 4 words that make your pulse race. Please, follow me now. You are escorted to a separate area toward the rear. The entrance closes. A different agent sits opposite from you, and he accesses your case file on his computer. He observes you and states, "I require access to 5 years' worth of financial account statements." And at that instant, you understand you possess nothing. You have no paperwork. You have no documentation physically available. You do not comprehend why he is requesting this. And while you are seated there attempting to determine what to respond, the timer is already advancing on a procedure that could result with you boarding a departure flight to your nation of origin before evening arrives with a 5-year prohibition recorded in your case, and no tribunal, no magistrate, and no additional opportunity. This is not a theoretical scenario. This is occurring to actual visa possessors and permanent resident card holders at this very moment at aviation facilities and terrestrial border crossings throughout the United States. And if you do not understand precisely why it is occurring and precisely what action to take, you face genuine danger. Let me explain what most individuals get devastatingly incorrect in this circumstance, because this is where the snare exists. And it is a snare that has already eliminated thousands of individuals from their immigration standing, their professional positions, and their existence in America. When a Customs and Border Protection agent requests financial paperwork at the border crossing, most individuals do one of 3 actions. They lose composure and begin speaking excessively, offering details they should never have disclosed. They become confrontational, which the agent interprets as questionable conduct, or they communicate nothing helpful because they simply never organized, never considered this could occur to them, and believed that possessing a legitimate visa indicated that the difficult portion was finished. All 3 of these reactions can hasten the pathway to what is termed an Expedited Removal Directive, and if you obtain one of those, your circumstances transform immediately and significantly. Under an Expedited Removal Directive, or ARROW, you are refused admission to the United States immediately. Your visa is invalidated without delay. You are positioned on a non-stop departure out of the nation, usually within 24 to 48 hours, and you are prohibited from re-entering the United States for 5 years total. There is no immigration magistrate. There is no tribunal session. There is no appeal mechanism in the conventional understanding. The agent who interrogates you is also the agent who produces the directive. According to legal information released by the Murthy law firm and verified by CBP's own operational structure, this procedure is completely lawful, completely in operation right now, and completely relevant to H-1B employees, F-1 students, B-1 and B-2 travelers, permanent resident card holders returning from international locations, and practically every other immigration classification you can imagine. The determination depends on the CBP agent's assessment in that instant, in that location, that you are inadmissible. So the inquiry is not whether this could occur to you. The inquiry is whether you are organized. Now let me provide you the legal structure you must comprehend, because understanding is your safeguard. Under the Immigration and Nationality Act, specifically under Section 212, an individual requesting admission to the United States must prove that they are not inadmissible on any of the enumerated grounds. One of those grounds located in Section 212A4 is the public charge basis. This indicates that if a CBP agent has justification to suspect you cannot financially sustain yourself while in the United States, or that you are probable to become predominantly reliant on the government for assistance, that agent can determine you inadmissible. Financial paperwork, including account statements, are one of the primary instruments CBP utilizes to assess your capacity to sustain yourself. This is not recent legislation, but what is recent is how forcefully and extensively it is now being implemented. Since January 20th, 2025, the present administration's executive instructions have substantially enlarged the enforcement approach of CBP and ICE at entry locations. Agents are now functioning under direct guidance to perform more comprehensive financial and biographical examination during admissions conversations, particularly during secondary examination. And because of the biometric entry-exit final regulation that became operational on December 26, 2025, every non-U.S. citizen's facial features are now verified against government information systems the instant they approach a CBP inspection station. If that verification retrieves any indicator in your file, any inconsistency, any omission, any previous immigration matter, the probability of secondary examination increases substantially. In secondary examination, the agent has expanded authority, additional time, and additional instruments. And under CBP Directive 33-4049A, they can lawfully examine every application on your mobile device, including your financial institution apps, transaction apps, and any financial documentation that are accessible on the equipment. This is the situation you are entering every single occasion you traverse a U.S. border crossing. Right now, here is where I must pause and discuss something that is circulating like an epidemic on social platforms, on TikTok, and in WhatsApp immigration communities because it is hazardous and it is incorrect. There is an assertion spreading right now that states CBP has no authority to inquire about your financial situation, that only USCIS can assess financial qualification, and that requesting account statements at the border crossing is an unlawful excess. This is entirely inaccurate. CBP has complete statutory power under the INA and under DHS regulations to assess financial admissibility at the entry location. There is another assertion circulating that states if you possess a legitimate visa, you cannot be refused admission for financial justifications. Also inaccurate. A visa is an authorization to journey to the United States to request admission. It is not a certainty of entrance. The CBP agent at the entry location renders the ultimate admissibility determination, and that agent is not obligated by the determination of the consular agent who produced your visa. I have observed individuals in discussion areas instructing others that they can simply decline to respond to financial inquiries by referencing the Fifth Amendment protection against self-incrimination. As a non-citizen requesting admission at the border crossing, you do not possess the identical Fifth Amendment safeguards as someone already within the nation confronting criminal charges. Declining to participate with a CBP admissions conversation is in reality treated as an inability to demonstrate admissibility, and that inability can and does produce denial of entrance. These misconceptions are not just incorrect, they are hazardous. Adhering to that guidance can position you in an expedited removal directive within hours. Now, let me provide you the response strategy, because this is the portion that will genuinely safeguard you. Tonight, after you view this video, here is precisely what you must do. First, retrieve your account statements from the previous 5 years immediately. Access your financial institution's digital portal. Transfer your monthly statements extending back 60 months and store them in a properly organized folder, both on your equipment and in a cloud storage profile you can retrieve from anywhere. If you maintain accounts with multiple institutions, do this for every profile. When a CBP agent requests you to prove financial stability, you want to be capable to display a transparent, consistent financial record. You want to display regular income transactions. You want to display that your balance is sufficient for your planned duration, and you want to display no questionable large currency movements in and out of the profile. If your statement record displays irregular sequences, get ahead of that by organizing a simple documented clarification for your documentation. Second, reproduce and transport a physical duplicate of your most current 3 months of statements every occasion you journey internationally. Yes, physically reproduced. CBP agents have documented power to examine your mobile device, but they cannot force you to access cloud profiles or distant servers. Having physical paperwork ready demonstrates that you expected the inquiry, that you have nothing to conceal, and that you are an organized, methodical traveler. That alone modifies the atmosphere of the interaction. Third, understand your admissibility status before you journey. Access your I-94 documentation at the official CBP website, which is i94.cbp.dhs.gov, and verify that your previous arrivals and departures are precisely documented. If you observe any inconsistencies, resolve them before your subsequent international journey, not during a secondary examination when it is too delayed. If you have ever exceeded a visa duration, experienced a previous removal, or experienced any matter at a U.S. border crossing, communicate with an immigration attorney before you journey. These indicators will surface in the CBP system the instant your biometrics are scanned, and a disorganized traveler with an indicator in their file is precisely the status that gets directed to the separate area. Fourth, if you are a lawful permanent resident, meaning you possess a permanent resident card and you journey internationally, you must transport proof of your connections to the United States in physical format every occasion you traverse the border crossing. This indicates your most current tax filing or tax document, your employment documentation or compensation records from the previous year, proof of your U.S. location, such as service bills or rental contracts, and preferably a correspondence from your employer verifying your continuing role. Permanent resident cardholders can be directed to secondary examination just like any other traveler. And in secondary, the inquiry of whether your residence in the United States is genuinely uninterrupted can arise. Account statements from a U.S.-based profile displaying consistent U.S. movement over multiple years are one of the most powerful pieces of proof you can offer. Fifth, if you are ever positioned in secondary examination and a CBP agent begins requesting detailed financial inquiries, here is precisely what to communicate and how to communicate it. Be composed, be straightforward, do not over-elaborate. If the agent requests where you are employed, you state clearly, "I am employed by," and you provide the designation of your employer and your position title. If the agent requests about your financial situation, you state, "I have my account statements accessible if you would prefer to review them," and you offer the physical duplicates you organized. If the agent requests an inquiry you genuinely do not comprehend, it is completely acceptable to state, "I want to ensure I comprehend the inquiry accurately. Could you please explain?" You are not being unclear. You are being exact. What you should never do is provide details that was not requested, because in a high-pressure secondary examination, additional details almost always generates more inquiries, not fewer. Sixth, and this is essential if you are produced any paperwork during a secondary examination, whether it is a sworn declaration, a summary of the conversation, or any document with your identity and case identifier on it, retain every single duplicate. These papers are the basis of any future legal examination, any petition for reconsideration, or any exemption submission. According to guidance from immigration law practices, including Murphy Law and Verdon Law, mistakes and misunderstandings by CBP agents do occur, and a documented account of what was genuinely communicated is vital if you must dispute a determination. My name is Ivy. I am a senior immigration analyst with 6 years of background, and on the U.S. Guide, I do not provide you perspectives. I provide you the protection approaches that maintain families united. What you just received is not intended to alarm you. It is intended to equip you, because the border crossing situation in 2026 is the most forceful it has been in over a generation, and the individuals who navigate through it without problems are not the ones with the most costly attorneys or the most advantageous visas. They are the ones who appeared organized. Immigration regulations transform overnight. Join my WhatsApp community for immediate notifications before I publish on YouTube. The connection is in the description below, and I want you in that community before your subsequent journey. As a reminder, everything addressed in this video represents confirmed data as of March 24, 2026, based on official CBP, DHS, and INA structures, as well as examination from Murphy Law, the American Immigration Council, and the National Immigration Law Center. This material is for informational intentions only. It is not legal guidance. For your particular circumstances, please consult a qualified immigration attorney. Policy modifications can and do happen. Always confirm with official resources before you journey. If this video assisted you, like it right now and distribute it with every visa possessor and permanent resident cardholder you know. It could be the most significant thing they view this year. If you want precise, rapid, and trustworthy immigration information, subscribe to the U.S. Guide right now and activate notifications. Staying educated is no longer discretionary, it is vital. I am Ivy. Safeguard your standing, safeguard your family.